Okay, good. Thank you so much. So this is my second time being able to talk with you, and thank you so much for inviting us. My name is Ron Chapman, and I'm the owner of Chapman Law Group. We are exclusively a healthcare law firm. We have, I think, 18 attorneys now. We're in 3 different states. We have offices in Miami and in Sarasota, and we exclusively deal with healthcare related issues. We have a criminal division, a compliance division, regulatory division, which Sarah works in, which means she only deals with, or not only, but deals exclusively with license, regulatory, National Practitioner Data Bank, peer reviews, credentialing, that type of thing. And then we have a compliance and civil litigation. Most of what we're going to talk here today about relates to compliance. Personally, myself, I have a master's degree in health administration. I also have a law degree, and I also have an LLM, which is a master's in law, in health law, from Loyola University. So up front on the screen here we do have a free guide that we send to physicians. So if anybody wants to send me an email, we'd be happy to send you the e-link or a hard copy of that for your benefit. Lawyer stuff I always have to talk about. We don't have a legal relationship, and nothing I say can be taken as legal advice that I'm giving you. If you want to talk to us, feel free to call, and we would certainly welcome that. One of the biggest changes that's happening, and it's one of the biggest changes of, or one of the biggest causes of criminal and other investigations, audit, is telehealth. So there's 2 sections in telehealth that we need to talk about. The first one is Florida recently created a statute which did away with the boards, the Board of Medicine, the Board of Osteopathic physicians, who had rather cumbersome rules that weren't very well defined. I've litigated many of them in front of the board, and you were always left wondering. So the legislature got involved, and the legislature created a statute that supersedes any of the rules. Now, there are some rules that a board can make that explain or implement the statute. That's part of administrative law, that boards and agencies can implement statute. But the statute is very specific now. You can do synchronous or asynchronous, meaning you can have a live conversation, or it can be a tape recorded one or some other means. Radiologists, for example, for sure, they get radiographs over the internet, and it's not an immediate interaction with anybody. But the one thing is important: you have to have audio and video. You have to be able to see the patient, and you have to be able to communicate in some way, whether that's pre-recorded or it's current now. And the big thing here is, how does that happen? It can be a cell phone. It can be through FaceTime. It can be through Zoom. It can be through any way that you want to accomplish that. But it has to be clear enough for you to be able to comply with the standard of care. And this is the biggest thing that I see personally with people that are providing telehealth. They're not applying with the current standard of care. And the way I like to tell them, if you would do it in the office, but you can't, you find it necessary for diagnosing whatever the healthcare issue is, and you can't do it telehealth, then potentially you're in violation of the standard of care, which means what? I mean, there could be a board action, or more likely, you could be sued. And there will be a plethora of lawsuits that will start happening probably by the end of 2021, going into 2022, and probably for as long as any of us are alive, related to the failure to conduct a proper examination over the phone, or over telehealth, video and phone. And give you an example. One of the biggest problems right now is people diagnosing issues that require DME equipment. They order a knee brace or a back brace or something. And the big question is, how are we able to evaluate the patient to know whether or not they had immobility or other problems in their knee in order to prescribe that? That's a big issue with Medicare. It's on the OIG's hot list that they're going after. The other things is only certain people can prescribe controlled substances. Psychiatry for the main part, are the ones that can do that. And here's a big one here. You must keep records, the same type of records that you would keep in the office. Later on, when we talk about false claims and anti-kickbacks, we're going to talk about that more. It is one of the items that Medicare, particularly Medicare, Medicaid, CMS, is using to revoke the privileges of physicians, which all of you should know. If your privileges are revoked from Medicare, that's a cascading event that takes time to occur, but eventually it causes you to lose your privileges in almost every state, and your license potentially can be revoked if that's done because of fraud. Now we have to switch gears and talk about the the federal government's interpretation of telehealth. And that changed March 6, 2020. Federal government modified the rules, and those rules are still in effect, and those rules will be in effect until the pandemic is over. I don't know when that will be, but eventually HHS will issue an order and say that it was over. It was supposed to be over the 15th of this month, but that's not going to happen. It's extended indefinitely. And what were the big changes in that telehealth? And I hope you really listen to me, because when the pandemic is over and the rules go back, these exceptions do not any longer apply. And the big exception here is you do not have to have a prior relationship with the patient. Once this emergency is over, unless HHS decides to keep that particular modification, you must have a prior relationship with the patient. The second thing is Medicare always required the patient to be in a designated area, primarily in a poor area, not in your big city locale type thing. Today they don't. They can be in their home, they can be in a poverty designated area, they can be in a hospital, they can be wherever they can be, and you can provide that service to them. Now, the issue of having a relationship with them, interesting here, it still is required, but HHS has issued a bulletin. It says, yes, it's required, but if you can't have one, we're not going to audit it. And we're not going to hold anybody accountable as long as the pandemic is going on. But make sure that you relook at your practices after. Now, you can also do e-visits where somebody's just checking in. Now, in an e-visit or somebody just checking in, that person has to have a prior relationship with you. You can't do it for a first time, and the patient has to request it, basically. Let's talk about the Stark Law for a moment. Stark Law hasn't changed in a while, except there are new safe harbors, some of which apply here that are more technical and we don't need to get into. But Stark is physician to physician. It deals with government programs and DHS, Designated Health Services. Basic rule here is you can't refer to your spouse. You can't refer to your brother who has, a healthcare program, or let's say has a PT, and you have a primary care and you want to refer there. There has to be a financial relationship or a relationship by way of relationship that the government collapses down and say, in reality, this is a financial relationship between. False claims are real important, and let's talk about those for a second. False claims can either relate to criminal claims or civil claims. A civil false claim basically means the government's getting some money back. Criminal false claim means that you could also go to jail. And what is a false claim? The Federal False Claim Act relates to Medicare, Medicaid, and any other government program, TRICARE, that type of thing. So when we're talking about a false claim here, we're talking about failure to have medical necessity. Here, I have a slide for you on some of the big ones. we're talking about failure to have medical necessity. We're talking about using modifiers incorrectly. Modifier 59 is an unbundling modifier, and I am seeing a lot in our practice of Medicare, Medicaid audits, even Blue Cross Blue Shield audits, United Healthcare audits, where the modifier was inappropriately used. Modifier 59 can only be used in exceptional circumstances where bundled activity needs to be unbundled. And then the number one code here that the government goes after and nails everybody they can is modifier 25. It's an E&M code that allows you to bill for a separate service that occurs on the same day that the E&M service was provided. And we're going to talk about E&M coding because that's changed dramatically, and we'll talk about that in a moment. Some of the other big ones is just not having proper documentation for the CPT code or the HPCS code that you've used. Documentation, everything is huge, and I'm amazed at the number of doctors that get in trouble that don't have proper documentation. It's so essential, and that documentation has to legitimately support the procedures that you're doing. Another big one that we're seeing a lot of lately is experimental treatment. And I don't know if it's just because we were retained by a number of people that got caught up in the same thing, using a product that they believe worked, but was experimental. An experimental product may be billed under the right code, but if it's experimental, it's not reimbursable. It's not reimbursable by Medicare, Medicaid, and it's not reimbursable by Blue Cross Blue Shield and other ones that are there. Supervision, big issue. Whether the conditions of payment require direct supervision or indirect supervision, you need to be aware of that, and it's extremely important. E&M coding. Just remember this. I don't know if someone else in presentation is talking specifically about coding, but the rules changed. No longer do you have to go through the cumbersome, is this a 215 or 213 or 214? It's based on time, and it's based on total time that you've spent. And I'll show you a chart in a moment. And with respect to that time, it's the total time, the time you spent with the patient, the time you spent reading a particular record, the time you spent ordering a test or something, the time you spent reviewing a test with the patient, the time you spent documenting. So you total all of that time up, and then that tells you which specific code. And that, relieves a lot of work from us. A lot of the audits we were doing in the last couple of years, probably the last 10 years, simply dealt with the physician's inappropriate coding. They had too many 15s, 05s, and not enough 13s, 03s, and they couldn't figure out, what was a moderate complexity, what was limited complexity, that type of thing. And here's the criteria, or here's the coding. If it's an 02, 15 to 29 minutes. If it's an 03, if it's a 12, 13. So now you're going strictly on time, but you still have to have documentation. The documentation has to legitimately support that it took you that much time to do whatever you were doing. So you must document these. Document, document, document. It's the number one thing that gets doctors in trouble in all things. Let's talk briefly about the Anti-Kickback Statute. And the big thing to know here about the Anti-Kickback Statute is there is a whole host of safe harbors that have now been reissued. Many of them were technical revisions of other safe harbors. And for those of you that don't know, a safe harbor is sort of a get out of jail free card. Safe harbor says this: if whatever you did complies with the four corners of a structure that the government put together that says, if you do it this way, let me give you an example. If you pay somebody based on a percentage and that person is a bona fide employee of yours, that's a safe harbor. So you can do that. And a safe harbor means the government won't come after you for doing that. And there's a number of them. Now with false claims or with anti-kickback, big thing to remember is you can't pay somebody and you can't receive money from somebody for either referring a patient or for accepting a patient. You just can't. And you can't even knowingly or willingly cause somebody to make a false statement. A lot of times you see this. I dealt with a very serious case yesterday. I'm not sure what we're going to do with it. We were auditing records because of a Medicare audit. Lo and behold, we found that two of the physicians were really sloppy at rewriting their records. They left timestamps in there. They left clear indicators. And when I talked to them, they said, yeah, we were just trying to make them better. But they didn't rewrite them in such a way where they documented that this was a delayed entry or anything, and CMS already has the record. So that's going to come up to be a big problem for them in the end. Florida Patient Brokering Act, big thing. It kind of parallels the Anti-Kickback Statute. Again, it says you can't pay commissions, you can't benefit, you can't do anything. And this relates to all physicians or all patients, all healthcare providers, all health insurance providers, everything. And the interesting thing here, it's fee splitting, it's bonuses, it's commissions. Now there are safe harbors, and the safe harbors here follow the same safe harbors as Stark follows, and many of the same safe harbors that the Anti-Kickback Statute follows. The big difference here is this provides to is applied to everybody in all of the various insurance carriers. Same thing with the Self Referral Act. It's inappropriate for providers to refer back and forth. This is very similar to the Stark law, and many of the same safe harbors apply to this one. Now, one of the major safe harbors that came about, and it's very hard to explain because when the government decides to do some, they make it very convoluted. The government explains this in 84 pages in their rulemaking, and then they reduce it down to a couple paragraphs. But basically, it's collaborative agreements, collaborative relationship. What the government has decided, and they finally woke up and saw, is there's great benefit when there's synergy and when there's collaboration between different physicians, between physical therapists and physicians, that type of thing. So the rules are very convoluted, but they do allow for collaborative agreements, and those agreements and those relationships will in fact not be looked at under anti-kickback. Now here's the problem. That provision came out already. We have a case relating to a collaborative agreement, and they simply didn't do it right. They didn't have the right agreement. They have independent contractor agreement, and it's a problem. I don't know the end result of it. We're still looking through all those. It's a relatively new case that we have. So let's talk briefly about some of the duties that a physician has. And these duties, they seem kind of basic, but they come up all the time. A physician has a duty to adhere to prevailing standards. That doesn't mean you can't use things off label. It doesn't mean that you can't do some unique therapies and unique treatments, because the standard of care varies. There can be a plurality for standard of care. There can even be a minority of people that do something that still is within the standard of care, because that's how medicine evolves. That's how it changes. You must act in a way that's acceptable, reasonable. Many of these relate to the ethical things that we were talked about. But one of the issues here that I want to raise here is, do we apologize when something goes wrong? It's a very interesting thing. I've spoken on this many times. I will tell you this, a simple apology often goes a long way to prevent a lawsuit or to prevent somebody filing a claim with the board. Now, the yin and the yang of that, in an apology, it's not this. You come out of the operating room and you say, I'm really sorry I killed your husband. That's not a good thing at all. But there are things that you can apologize for. And sometimes an apology, it's just showing empathy, that you understand that something happened that's causing pain, and you share a hand, you talk to them, you sit down and you take some time with them. Oftentimes, one of our divisions does a lot of medical malpractice defense. And oftentimes, what the plaintiffs often say is, I just wanted the physician to care. I just wanted the physician to understand the problems they're causing, they were causing me. One of the other areas that comes is you have a duty to supervise subordinates. Now, subordinates generally here, we're not talking about nurse practitioners and PAs. I mean, there are agreements with them, but that's not the kind of supervision I'm talking here. I'm talking about medical assistants. I'm talking about the nurses that work in your office. I'm talking about phlebotomists if they work in your office. I'm talking about the receptionists. And oftentimes these people will do things outside their scope of practice, and those are problems. Make sure you run a tight ship and you know what your ancillary staff are doing, and you know what they're doing is within the standard of care. It's very important. Financial responsibility, this really hasn't changed. If you don't have insurance, you have to have a letter of credit. That letter of credit has to be current, and the letter of credit has to be greater than or equal to $250,000. You just have to. Now, I represent a lot of doctors that go bare. And going bare basically means they have a letter of credit, but they don't have any insurance. Now, sometimes it's because they can't get insurance. Sometimes they just want to pay the premium. But here's the thing to remember. The average defense for a medical malpractice claim is between $75,000 and $150,000. So oftentimes, you only have to have one claim to cover insurance maybe for 2 or 3 years, depending upon your specialty. So give that some real consideration. You might save $20,000, $30,000, $40,000, but you might be setting yourself up for significant attorney fees. And then, of course, if you lose, you're going to have a problem. And while most attorneys won't go after personal assets, there's nothing that prevents them from doing that, but generally they don't. So you want to be considerate of that. A release of records. Here's an interesting. Most of you know that you have to release records to your patient. Most of you know you have to keep records. Florida law and federal law in some cases is a little different. And it's not with respect to release of records. It's just records in general. Florida law says that the physician is responsible for maintaining records. However, if the physician is a bona fide employee or there's a contract, you might be an independent contractor, but you're a contractor, and the contract specifically says that the employer is going to maintain those records, then you don't have to maintain them. You should have to prepare them correctly. But there's a problem. Federal law, Medicare regulations, particularly if you ever are prescribing DME equipment, say that the physician must maintain those records in their possession for 5 years. Now, how is that a problem? Well, the DOJ and the OIG have latched on to this novel way of coming after doctors. So let me give you a hypothetical. The DOJ goes after a telehealth, telemarketing operation, and they take down that operation. They take all the records, they take down all that operation. And then it used to be very hard and cumbersome in use of resources to come back after all the physicians that were prescribing the DME, all the physicians that were involved. So what they did is they made a change. They didn't make a change. They latched on to an anomaly. And that anomaly is, it is a regulation, a requirement that you maintain records. You, not your employer, not where you work, the person that prescribes the DME must maintain those records. And in maintaining those records, you have to have them for 5 years, and you have to be able to send them to Medicare if they're asking. Now, what is that? What happens with that? We have 7 appeals now in front of CMS where physicians were involved in this. They did not maintain the records, and they were revoked. And you can be revoked for 1 year for each offense. And if you revoked, that has a cascading event. 3 of them are world-class physicians that did this for a little bit of adjunct income. Just be aware of that kind of stuff. You have to do it. Know your regulations. Am I running out of time? Okay. And that's it. I'll wrap up right now. The last ones were prescriptions. Just make sure you're writing correct prescriptions, that they document the correct things. So thank you so much. Again, if you want to email us, feel free to do that. These slides will be available if you want to look at them. If you want a copy of the compliance book that we drafted, feel free to email us, or maybe Valerie, if you email her, she can get it to us. And thank you so much for your time.